Okay, you're all set, Senator.
Okay, thank you. Good morning and welcome. I am Senator James Gray. Today we will be having a public hearing on Senate Bill 89. Before I get started, I will read through the checklist to ensure that the meeting that we are holding is in compliance with the right to know law. As chair of the Senate Election Law and Municipal Affairs Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom webinar for this electronic meeting. All members of the committee and select legislative staff have the ability to communicate contemporaneously in this meeting through this platform. The public has access to contemporaneously watch or listen to the meeting on Zoom and YouTube and via the phone by following the directions and links provided on the General Court website. We have provided public notice of the necessary information for accessing the meeting on the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call 603-271-6931. In the event the public is unable to access the meeting, we will adjourn and reschedule. Please note that all votes taken during this meeting shall be done by roll call vote. Finally, let us start the meeting by taking a roll call attendance. When each member states their presence, please also state where you are and if anyone else is in the room with you during this meeting, which is required under the right to know law. I, Senator Gray, will call the roll. Regina Birdsell, Senator Birdsell.
I am here in my home in Hampstead, and my husband is working up in the office and will be coming in intermittently into my office, the kitchen.
Okay. Senator Ward.
I'm in my home and started. My husband is in the house, but I'm alone in the room.
Senator Susie.
This is Donna Susie. I'm at my home in Manchester and I am alone.
Senator Perkins Quokka.
Senator Perkins Quokka, I'm at my office in downtown Portsmouth, New Hampshire, and I'm alone in this room.
And I am Senator James Gray. I'm at my home in Rochester in District 6, and I'm alone in this room. Okay. That part being done, is there any discussion before we start the first bill, 89? Okay, if there's not seeing any, I will step down and the vice chair will take over the meeting and introduce the prime sponsor of Senate Bill 89.
Thank you, Mr. Chair. I open the hearing on Senate Bill 89 and invite the prime sponsor, Senator Gray, to introduce it.
Thank you, Senator. My name for the record is James Gray, and I am the prime sponsor of Senate Bill 89. It's a piece of omnibus legislation that deals with 5 separate parts. I will go through those in just a minute. These things that we're about to talk about have been brought either from agencies inside the New Hampshire government or from constituents that are concerned about the issues. The first part of the bill is the chief election officer. Right now, every town in the state of New Hampshire has a town clerk, and that town clerk has to be a resident, a voter in that town. For the cities, however, there is a provision in there that the city clerk has, in addition to many of the roles that she plays or he play in that process, also has a title of chief election officer. This has caused conflicts at some of the polling locations inside the cities because the other parts of the statute clearly make the moderator the person in charge at the polls. And so the only thing that this bill does is it removes the title. It does not take away any duty. It does not take away anything else. And again, it's an effort to resolve any conflict between the city clerk and the moderator. One of the things that has brought this to the fore is that there is no statutory requirement for a city clerk to be an inhabitant of the city in which they are the chief election official. And that happens quite frequently across the state in the various cities. But in addition to that, it does not require that the city clerk be a resident of New Hampshire. In fact, we have at least one that I know of where the city clerk is actually in the next town over, which happens to be in a different state. And again, this is causing concern on many levels. So certainly when we get into talk about that, that is one of the things that you should consider is whether or not the chief election official in the cities should have that exemption, not being a resident. Part number 2 is the prohibiting the taking of certain photographs within the guardrail. This comes from a piece of legislation that for years was on the books about not taking photographs of a ballot. And the courts found that a person who wants to take a photograph of their ballot certainly should not be denied that. And we understand that. And we will support that. But if they're taking a photograph from inside the guardrails, they should not be taking photographs of other people and other people's ballots. So we're trying to look at that statute and make sure that that makes sense. Certainly with the proliferation of cameras and the number of megabytes that even a cell phone camera can do, even a picture of someone could capture not only that person, but another person, and possibly even be able to be expanded so that they could read the ballot. And that's certainly not the intent of, I believe, anyone on this committee, that someone else be able to look at your ballot. And this becomes more poignant when you look at our last election. And to cut down on the size of the ballot, we not only printed races on the front of the ballot, we also printed them on the back of the ballot. And most people don't avail themselves of one of the privacy envelopes to put the ballot in while they transport it from the voting booth to the actual ballot box. And that makes it much easier for someone to capture information about your ballot. Others that follow will describe that in more detail. Allowing the opening of the absentee ballot outer envelopes and pre-processing absentee ballots. One of the very popular things that we did for the election in both September and November of last year was the pre-processing of ballots. Many of the moderators wanted us to go further, wanted us to be able to mark the checklist such that the person had already voted. In New Hampshire, the laws have changed over the years. If you go far enough back, I believe that all of the absentee ballots were not opened until the closing time of the poll. And that was to give anyone who wanted to vote in person the whole day to vote in person. And then that was moved back to 1 o'clock. It was moved back to 2 hours after the polls opened. It was in this last two elections, September and November, it was moved back to 1 hour before the polls closed. So the pre-processing, especially in times of a large number of absentee ballots, is very popular. Marking up the checklist so that they can process the people through on election day much more efficiently. Certainly, I have no problem with that as long as removing the ballot from the inner envelope and the marking of the checklist with the red AV, which are the two things that signal that the person has voted, do not happen until election day. And then the thing that I didn't talk about there was opening of that outer envelope. Again, very popular to open that outer envelope because it gave an opportunity for people who did not complete the process on the affidavit properly. They didn't sign it. They did something else that was not, and there's really no reason why we need to include that in the process of processing absentee ballots. It can be separated from that. And as I've stated to many people, if a person somehow destroyed that outer envelope that was sent to them by the clerk and used another envelope, we would still accept that ballot when it got to the clerk. And in fact, the clerk, not knowing it was an absentee ballot, would open it up and seeing the inner envelope with the affidavits and stuff, would simply put a piece of tape over the top of it, put it in the pile, process it, adding the application, etc., as to the rest of the law. So it is not unprecedented that this happens. It's just right now not codified in law that that's what you would do. So this portion of the bill talking about pre-processing, or should I say opening that outer envelope, allows us to make sure that we do not disenfranchise voters that simply, due to one reason or another, have not completed that process properly, and therefore we would not be able to do it, process that ballot. And again, from the feedback that we got from this September and November about the number of people who were able to cure the problem, even though we only did it 3 or 4 days before the actual election, this would open it up as soon as the clerk starts to get those ballots back and has established a procedure to do it, that they would be able to open those outer envelopes, look at the affidavit, and then contact the voter if the voter has provided the contact information. Moving on to part 4, establishing a committee to study post-election audit and counting devices. Very interesting if you look at this in light of the Wyndham situation, which we have talked about both in regular committee parts and in executive session in this committee. To have voter confidence, there are many people who do not trust the machines. There are people who want to go back to complete hand counts and not use any machine at all. As a moderator for well over 20 years in the city of Rochester, in Ward 5, and then when we redistricted Ward 6 in Rochester, I can tell you that it takes a considerable amount of time, even in a small ward, and at that time it was between 2,000 and 3,200 people who were on the checklist. It takes a lot of time and a lot of people coming back to the poll to help out, to be able to do those counts and do them efficiently and do them in the amount of time. I can also tell you that the accuracy of hand counts on election night by people who have been at the polls since 6, 7, 8 o'clock in the morning, and now are starting this hand count process at 8 or 9 o'clock in the evening, that errors are sometimes made, unintentional, but the process is not flawed. And if you go to many of these recounts that we've conducted in the state, if you are recounting a race that is a hand count town instead of a machine count town, your expectation that there is a difference that is notable is much higher in that hand count town. Now, that is not to say that the procedure used by the Secretary of State in doing the hand counts at a recount is not much better and much more accurate. I believe it is. We've made a couple of suggestions on how that can even be improved, though, by counting not only the votes for the candidate or question, but also counting undervotes or overvotes, sometimes referred to as blanks, so that we do have a number of the total votes that were cast for that, or the voter chose not to cast a vote for that. And that will help the accuracy of even the Secretary of State. But we need to pursue that. There's the Commission on Elections down in Washington had 2 findings against New Hampshire. It said New Hampshire did not have an audit procedure for checking the machines, and it did not use a device that was certified by their organization. Now, we only have one machine, and that machine was certified by our Ballot Law Commission after going through a review process that was conducted by a commission set up by the legislature. And it was a very rigorous process. We disabled ports. We did other internal modifications to those machines, and they were certified before this commission came into existence. And that certainly, talks to why our machines would not be certified by them, because they did not, to the best of my knowledge, go back and recertify any older machine that was out there. They only concentrated on new machines that were coming in. But it does affect us going forward. In the future, we are going to need to replace the AccuVote 2000 machines because they're no longer manufactured. Their parts for them are not readily available. In fact, I'm told that we've been buying machines from other districts, other states, and cannibalizing some of the parts out of it to keep the ones that we do have operating as efficiently as we had. And many of you will think back to the election in November, where several of the machines did have problems during Election Day. And again, most of those can be traced directly back to the age of the machines. And so the next one is probably the most controversial of all of the things that are on here, and that is the duties of the Register of Probate. I know that Mr. Head is going to represent the courts today, and he did provide his written testimony. You will have several people who will talk on that issue, including, I'm told, 9 of the registers of probate are in attendance. Only one of them is scheduled to speak, from what I'm told. But again, those things change. We are not trying to go back to the way the registers were pre 2011. There was in the budget that year, one of the things that was done to help balance the budget was many changes in the court system. And certainly we're not trying to go back and reinstate those duties as it was. But what we've heard is that there's a lot of people who normally would be able to conduct a probate process pro se without an attorney, that are, because of the complicated nature and the lack of a person to talk to and know what the process is, are not only forced to pay a substantial fee to the court, but also a substantial fee to an attorney to help them through the process. And since I will be able to talk about that when we get to executive session, I'll just leave you with, if you look at some of the numbers that Mr. Head provided you in the testimony that he will talk about, talks about 7,319 estate cases. And that if you look on the next page, he talks about the number of phone calls they received in 2019 for probate queue. It was 46,396. That's over 6 calls per probate case. And if you figure that attorneys are processing about half of those and probably don't need to make any calls, they can just go into the electronic system and check on it or provide additional information. That number of calls per probate case in 2019 could be astounding. If you look at 2020, there was 35,951 calls, according to the information in there. Are we treating the people who are going through this process the way you would want to be treated? You've just lost a loved one. You are now, according to probably their will, being asked to be the executor. The first thing you do is fill out the information on their electronic system now and petition the court to assign you to be the executor. Then you have an inventory done, and then we pretty much sit on it for about 6 months to let other people who may have claims against the estate assert those claims while we advertise and we go through the process. We are not trying to take back any of the duties that were given to the clerk of the circuit court. We are trying to provide assistance, answering questions about the computer system, answering questions if someone says, I don't know what to put in block 2. And again, we are not trying to provide any information such as that. We're not asking for confidential information from people who haven't asked for the assistance. We dropped the request for a computer system. We'll either use a separate computer or we will use the kiosk at the courthouse. Again, we want to provide that service, and there are counties who have contacted both myself and others that say they want to provide that service, but they can't do it without some compensation, and this bill would give them that compensation. So I've talked for too long already, and I'll shut up now. And in case anybody has any questions of me, or you can ask the smart people who will follow me.
All right. Thank you, Senator Gray. Any questions from the committee? Senator Susie.
Thank you, Madam Chair, and thank you, Senator Gray. Just one question regarding Part 3, and that is the opening of the absentee ballots. As I read this section, it appears to me that that could potentially be a rolling process where the clerk could open envelopes every day leading up to the election. It concerns me that a process like that may reduce the transparency that we currently have in the process, where people can go and observe processing. And also that processing will now be somewhat inconsistent without the cities or towns having a set period of time. So I just wondered if you could speak to that issue, if that was the intent.
Certainly. The intent is that the clerk open those envelopes, giving the maximum amount of time to cure any irregularity that is found, and the process, remember, we are not opening the inner envelope. We are not opening any of those things. Right now, ElectionNet provides lists of people who have requested absentee ballots, have returned absentee ballots, etc. And so the moderator on election day, or during the time that he's chosen to advertise for pre-processing, will have those lists from ElectionNet, will have the unopened and be able to inspect those inner envelopes to make sure that they have not been tampered with. And again, that is the portion of the system that I am concerned about, is to make sure that there was no tampering, that the inner envelopes were there, and that everyone who requested an absentee ballot and everyone who returned one is on that list for inspection. And we did move the challenge, which was in Bill 1166, I believe is the number, to election day instead of having it done at the pre-processing. And the reason for that is that we're trying to safeguard the information that the voter, if they're away from their home for a particular reason, we're not trying to advertise 5-6 days before the election that they're not going to be around. And also for the ease of the people who might want to do the challenging, if I have it on multiple days, that creates a larger hardship on them, where if I do it on election day, I can solve some of those problems too. I hope that answers your questions. I'd be happy to try again if you wanted to define it further.
Thank you, Senator Gray.
Thank you, Senator Susie. What I'm going to do is I've asked the host to call on individuals who would like to speak on the numbers of the bill chronologically. So we'll go part 1, part 2, part 3. So we're not jumping back and forth. So with that, are there any other questions of Senator Gray from the committee? Okay.
Okay. So I just wanted to say, so we're going to start with part 1. There is a sign up list, and I just wanted to make clear that we will, anybody that signed up to speak on the sign up sheet online, you will get called. But Kirsten is going to call each part of the bill. And if you would like to speak to that part of the bill, please raise your hand. And at the end, we will check the sign-in list. But it is helpful if, as she calls the parts, you raise your hand so that you can be called in the chronological order that Senator Birdsell would like to go in. So with that, Kirsten, go ahead.
Thank you, Tricia. So if you would like to speak on part 1 of the bill, which is relative to City Chief Elections Officer, please raise your hand now. And we have Daniel Healy. Mr. Healy, you may unmute yourself.
Hi, Daniel Healy, Derry Town Clerk. I just had more of a clarification question. You mentioned, Senator Gray, that the city clerk, you mentioned something about the city clerk living in the city. That's not in the bill, correct?
Normally, since I'm the sponsor of the bill, I don't take questions during that period of time, but if the chair will allow.
I just, because where you mentioned it, you spoke on the city clerk not living in the city, but I didn't see anything on that in the bill. That's why I wanted some clarification, because it doesn't appear that the city clerk needs to live in the city, but you mentioned.
Correct. The bill is not trying to mandate that, but if you don't live in the city or you don't even live in the state, the question is should you have the title of chief election official?
Okay, thank you. That's all I have on this part.
Thank you, Dan. Anyone else?
All right. So if anyone else would like to speak on part 1 of the bill, please raise your hand now. And Senator Birdsell, not seeing any more hands for part 1.
Okay, part 2.
All right. If you
Prohibiting the taking of certain photographs within the guardrail.
If you would like to speak on part 2 of the bill, please raise your hand now. And I'm not seeing any hands to speak on part 2 of the bill.
All right. Part 3, allowing the opening of absentee ballot outer envelopes and the pre-processing of absentee ballots.
All right. We do have a few hands for part 3. If anyone else would like to speak on part 3, please raise your hand now. All right. And I will start with Giles Bissonette. All right. You may unmute.
Welcome, Giles.
Thank you, Madam Chair. Can I be heard? I just want to make sure the technology is working.
We can hear you.
Oh, great. Gosh, I always worry about that. Thank you, Chairman Gray, Chairwoman Birdsell, members of the committee. My name is Gilles Bissonette, Legal Director with the ACLU of New Hampshire. And just wanted to talk about just one concern that we have with Part 3 and the pre-processing procedures. And I just want to say at the outset that I appreciate very much Senator Gray's efforts to memorialize pre-processing. I think we've learned how important it is, and it's certainly something that we support and have no objection to. The concern I just wanted to raise is in Part 3, and in particular, page 2, lines 24 and 29, how this pre-processing procedure could reinstitute something called signature matching or signature comparisons. This was something that happened in New Hampshire for decades until a few years ago after a court case. And what happens under this signature comparison process is that then a poll worker would compare the signature on the absentee ballot affidavit envelope with the absentee ballot application. And a court struck that process down because it's really fraught with error and there was no due process embedded within that. And every election, hundreds of voters, lost their right to vote as a result of that signature comparison process. So one of the things that this bill could do in reinstituting pre-processing, again, which is something we support, it could effectively reinstitute signature matching, which is something that just we find problematic. So I think the first thing I just want to articulate with that concern is just how signature matching is inherently unreliable. And we think under this process, even with due process, it would just add burdens to the voting process for voters who are far more likely to be legitimate voters. And with respect to signature matching, potentially add unnecessary burdens to poll workers. So based on the work that we did on our lawsuit challenging the signature mismatch process, we didn't see any evidence that any of the voters in the most recent elections, 2016, 2012, that were disenfranchised as a result of this process were actually ineligible to vote or engaged in any form of voter impersonation or fraud. In fact, there have been some isolated incidents, of course, of absentee ballot voter fraud, but we haven't also seen any evidence that any of those instances were caught through the signature matching process. And I think second, relatedly, we just think it's inherently unreliable. There are multiple reasons, of course, why a person's signature may differ on more than 2 occasions: age, disability, et cetera. And so I think as a result, folks who are going through this process, they have no handwriting identification training, and I think they're more likely than not to erroneously conclude that 2 signatures don't match. And I think lastly, our concern with just signature matching in general is that historically it's been, not surprisingly, very uneven in how it's been implemented. So during the 2016 election, all of the rejections due to signature mismatch came from 26% of New Hampshire's 318 polling places. The remaining 74% didn't reject any absentee ballots due to a signature mismatch. So all of this really led the court in the Saucedo case that we litigated. Our lead plaintiff there was, by the way, a 95-year-old woman who lost her right to vote due to signature mismatching. The court there kind of highlighted just how this process is fraught with error. Moderators, conceive the relevant matching standards differently. The task of handwriting analysis is fraught with error, et cetera, were some of the things that the court raised. The last point I want to make is, because this is fraught with error, I'm just not necessarily, I still think that the pre-processing problem issue in potential remedy to this is still inadequate. And I just wanted to highlight a few points on that. So the notice and cure provision, I think as Senator Susi articulated, isn't necessarily uniform. It will depend on when the ballot is received. So for example, a voter who submits a ballot received 2 weeks before the election will have more time to cure than a voter who submits his or her ballot, say, the day before the election. And so if a voter submits it the day before the election or on the day of the election, that voter is going to have potentially no notice, and certainly, if notice is provided, not a substantial opportunity to cure. And I think the last concern we have with this potential due process is that the standards, again, aren't uniform. So the bill doesn't specify how quickly a public official shall contact the voter. The bill doesn't specify, of course, how much notice a voter should get. And I would note that I support this pre-processing regime for things like where a signature is omitted. But with respect to signature mismatching, there needs to be, I think, actually even more robust due process, because just the signature mismatch process is just more fraught with error in determining whether or not a vote is fraudulent or proper or not. So that concludes my testimony. Again, it's a concern with that portion, but I appreciate very much the efforts of Senator Gray, to codify pre-processing, because again, I think it is important and vital. Thank you so much.
Questions from the committee? Seeing none. Giles, I do have a question. Am I correct? Did you say the lines 25 to 29?
Yes. So I'm on part 3, page 2, and my testimony is really focused on line 24 and lines 25 through 29.
So I didn't see anything in there that says that references signature matching.
Yeah, so that's correct. It's not explicitly in there, Senator. If you look at lines 24, the affidavit shall be reviewed pursuant to RSA 659:50. And that statute actually is the statute that goes through and codifies the signature matching process. So at least the way that we read the statute is that now when you look at paragraph 4, there'd be a signature mismatch review process, and then those ballots that are potentially called out as a result would be subject to that type of notice provision on lines 25 to 29. That's how we read it.
Okay, thank you.
Thank you.
Any other questions from the committee? Seeing none. Thank you, Giles.
Thank you.
Next speaker is Maureen Hurd.
Welcome, Maureen.
Can I be heard?
Yes, you can.
Thank you so much. Thank you for the opportunity to provide testimony on Senate Bill 89. My name is Maureen Hurd. I am a retired Coast Guard officer and a Derry resident for the past 18 years. I am opposed to restarting the signature matching of absentee ballot applications and affidavit envelopes. I was a plaintiff in the Saucedo versus Gardner case. I was disenfranchised in the 2016 general election due to a signature mismatch. My ballot was disqualified by a town election official who more than likely was not a handwriting expert and who was using no consistent guidance to do the matching. Through no fault of their own, they're not meant to be handwriting experts. I had no notification that my ballot was disqualified until well after the election. Had I been notified before the election, I'm not even certain that I would have been able to prove it was my ballot. I was out of town on election day. Before the election, I had handed my ballot to the town clerk. I went there directly because I wanted to make sure that it was done correctly. And then I left and I was I was in Washington, D.C. on election day. Without a consistent approach to contacting voters and allowing time for a voter to respond, I feel that a cure in this instance is not possible. My daughter is a registered voter in New Hampshire. She is also an active duty Air Force tech sergeant currently serving in Germany. Because of the time difference, my daughter's electronically sparse working environment and other potentially unforeseen complications, I believe that there is a high probability she would be a failed contact should she choose to file an absentee ballot from Germany. She would essentially be disenfranchised because she is a military member. And it would make, if she, because of the mail, which is very problematic coming back and forth between Europe and the Pacific, she might not get her ballot in till election day or just before. She might be disenfranchised because of the inability to contact her and cure the ballot mismatch. We really must prevent this from happening. We can't allow our people to be disenfranchised. Thank you very much for the opportunity.
Thank you, Maureen. Any questions from the committee? Seeing none. Again, thank you, Maureen.
You're welcome.
Our next speaker is Margaret Burns.
Welcome, Margaret.
Good morning, members of the committee. Good morning, Senator Birdsell. I'm Margaret Burns, the Executive Director of the New Hampshire Municipal Association, and I'm here this morning to support Part 3 of Senate Bill 89. We do not have any position on any other parts of the bill. In short, Senate Bill 89 creates more efficiency in the absentee ballot pre-processing process. It requires the clerks to essentially open the outer envelopes as absentee ballots are received. And then it allows the moderator to authorize pre-processing by making notations on the checklist to help facilitate processing on election day. Although we are also proponents of the flexibility provided by last year's House Bill 1266, because it allowed for the reading of names and challenges to be done before election day, Senate Bill 89 would provide incremental efficiency for municipal officials by allowing some level of pre-processing to occur before election day. Having listened to the testimony that came before me, I also wanted to comment on the signature matching issue. Signature matching has been deemed unconstitutional and illegal previously by the Federal District Court, and the Secretary of State's office makes it very clear, communicates very clearly to election officials that that is an improper practice. I do understand that the statute is still on the books despite that federal district court ruling. So I don't know if that is perhaps what is creating some level of concern, but I see no reason why Part 3 of Senate Bill 89 would create or allow election officials to engage in a process that has already been deemed illegal by the federal district court. So I leave it to the committee to determine what level of pre-processing is most appropriate, and happy to take any questions the committee may have.
Any questions from the committee? Seeing none. Thank you,
Thank you.
Margaret.
Our next speaker is Janice Kelpel.
Welcome, Janice.
Thank you. Good morning, Chairman and members of the committee. I also want to talk about the signature match issue. In 1993, my husband was diagnosed with Parkinson's disease, and there were a couple of things that led to that diagnosis. Most notably was his inability to move one of his arms freely and his tendency to lose his balance if he tried. And the other was his handwriting, which became extremely tiny and very difficult to read. When he was diagnosed, neither one of us knew what we were in for, and we were quickly got quite the education. Eventually, it's a progressive disease, and like I said, he was diagnosed in 1993. So over the years, it took its toll in a million ways. When he was initially diagnosed, like Michael J. Fox, he had early onset Parkinson's. He was still working, and writing was a part of his everyday life. He would ask me sometimes to read his briefs, and it was ridiculous even trying to decipher his handwriting. I tried not to. At first, we kind of laughed at it, and then I realized how frustrating it was to him. Eventually, fast forward a couple of decades, he ended up having to go into a nursing home, which required me eventually, after trying to pay for that for a while, to file for Medicaid. This meant I had to close out every account that we had, and it required a lot of signatures from my husband. And it honestly, prior to when it wasn't legal documents, he would just ask me, well, just sign it for me, because it was so frustrating to him to try to do it. But when it came to legal documents, obviously I wouldn't have been comfortable with doing that. So I literally would take 5 to 10 copies of a document into him with a variety of different pens, hoping that maybe with a felt tip pen, that the pressure that he needed to exert to have it even look like it was possibly a signature might be easier with one kind of pen than another. And literally from one moment to the next, I could get sometimes a long scrawl out of it. Sometimes it would just look like a few dots. I could have written his signature much better to make it look like what was in his voter file than he could at that point. And when I first heard about the issue of the signature mismatch and people's ballots not being counted, I was furious, actually. It was really always important to him to be able to go and vote. I helped him struggle to get into the town hall in Franklin so that he could cast his vote. And in 2016 was the first time that he finally filed an absentee ballot, because it had become too difficult for him to be able to do that. But the idea of him, I mean, he lost enough of his dignity and enough of other parts of his life. The last thing in the world he should have to lose is his right to have a voice because his signature didn't match. So I think there are so many cases where you can't literally from one time of the day with Parkinson's, depending on medication, you can either be, they call it off periods and on periods. If somebody is off, they can barely move. My husband was so rigid, he could hardly move at all. His signature was insanely tiny. Sometimes literally it would be like 3 dots on a piece of paper. Nobody would have been able to, even a handwriting expert would have had difficulty with that. But certainly they would at least have the experience of knowing that some diseases cause problems like this. But I'm very worried about people who have disabilities losing their voice because of a signature mismatch. And that's it. Thank you.
Thank you, Janice. Any questions from the committee? Seeing none, again, thank you for your testimony.
All right, our next speaker is Daniel Healy.
Welcome back, Dan.
Hi. Daniel Healy, Derry Town Clerk. I just want to say for my town, we have about 24,000 registered voters. In November, we had about 6,500 absentee ballots. We pre-processed over 2 days, about 2,000 ballots each day is what we had at the time. And it did help us. I just have some suggestions with the language of this bill. On part 3, line 17, the opening of the absentee ballots in the outer envelopes is really the responsibility of the moderator. So it's not the town clerk that would do that. It's the moderator that does the pre-processing, and it's the moderator that opens the ballots on election day. I also believe that town and city clerks should have the option if they'd like to pre-process or not pre-process. So I'd suggest changing shall to may. For a town election, right now, we currently have about 80 absentee ballots. We don't really see the need to pre-process right now. So I believe it should more be an option for the moderator if he or she decides to pre-process. I spoke with my moderator last night, and she offered a few other suggestions. There's no current procedure right now for what to do with the ballots after they've been pre-processed. What we did in Derry's, we sealed them in a box with the tamper-proof tape, marked on them what they were, and then they're open again on election day to go through the machine. So we just would like something that says after the moderator has pre-processed, what do they do with those ballots? And those were our suggestions, and I'd be open to any questions.
Any questions from the committee? Seeing none, thank you, Dan.
Thank you.
All right, so for our next two speakers, I have Mr. Gardner here, and I also have Janice Kelble for a second time.
Okay, why don't we hear from the Secretary of State's office?
All right. Mr. Gardner.
Good morning. Good morning, Madam Chair, Senator Birdsall, and your fellow senators on the committee. We support all 5 sections of this legislation. I was going to speak on each one, but I don't think doesn't appear to be necessary. I'd answer any questions that senators may have. Number 5, the Secretary of State's office has, because of the Archives Division, a connection with the registers of probate over the years. The probate records that are in the archives, the registers have worked with the state archivist about the protection, safety, and longevity of those records. This past election, as Senator Gray mentioned, 633,000 New Hampshire voters actually voted for the Register of Probate. They run in each county, and after the election, they've been meeting. 9 of them have been meeting, as their predecessors had done in years past. And they talked about this legislation and the idea of retaining some of the duties that historically the registers have had. And at the first meeting, they chose from amongst the 9, Jane Bradstreet, who was a registered probate before everything was changed. And and is today, and has worked with the court. And she spent considerable time with all of them, particularly the new ones. So they have asked her if she would speak on their behalf. Some of them would like to speak as well. But so I would like to turn it over to Jane Bradstreet, if that's okay, Madam Chair.
The Secretary of State, Gardner, we're not on that section as of yet. I think it's section, what, 5?
We're currently on section 3.
We're on section 3 right now, and I'd like to wait until the
Okay,
end of section
okay,
5
that's,
to hear from her, if that's okay.
yeah, that's fine.
Okay,
I thought, okay.
thank you. Who do we have? We have Janice for a second time.
It looks like Janice put her hand down, and I think it was a mistake.
Okay.
So if anybody else would like to speak on part 3 of the bill, please raise your hand now. And I'm not seeing any additional hands for part 3.
Great. Okay, we'll move to part 4, which is establishing a committee to study post-election audit counting devices.
All right, and if anybody would like to speak on part 4 of the bill, please raise your hand now. And I'm not seeing any hands for part 4.
All right, let's move to part 5, relative to the duties of registers of probate. And I think we can call on Jane Bradstreet.
All right.
Unmute. Can you hear me now?
We can. Welcome, Jane.
I'm not used to not having to look at myself while I talk, so. And we've gotten used to this Zoom over this difficult year, but not quite used to all the technology pieces of it. Thank you, committee, for allowing me to speak. Thank you, Madam Chair. I have spoken on all the various bills that have come before you since 2011. I sent in some written testimony that kind of went over the history of it, and I won't belabor that. You guys can read that at your leisure. But in response to some of the issues, I would like to say firstly that the record that the probate division now creates and has been created over the years by the probate court, that registry works hand in glove with the registry of deeds to prove the ownership of all the land in all of New Hampshire. So it is very important. It's a very important historic record, and the registers have not been allowed to perform this duty. They have they still have the duty. It's still a misdemeanor if they don't perform the duty, but they have no cooperation from the courts to perform this duty. And I think this bill may rectify some of that. Number 2 issue is the customer service issue. And I was the register in 2011 when the bill changed, and I was offered the position of the manager of the Court Information Center, which didn't exist at the time. And I created it with the help of a lot of tech people in the court. And we created a call center, if you will, an 800 number, which I had been encouraging the court to do for many years. And so they finally did it with the execution of the 2011 bill. And I worked very hard to make that a very good and efficient call center and to help people as well as we could. However, I don't know how many of you may have tried to get help with a computer program over the telephone. It can be less than a satisfying experience. And as we just learned earlier, how many calls the call center gets, that are a state or probate case jurisdiction division. In 2019, it was over 46,000. And in 2020, 35,000 calls that are just related to probate. They get about 500,000 calls a year, excuse me, about 500,000 calls a year. And so it's a smaller percentage, but those people who call or have to use probate processes, are having to use it for no fault of their own. It's all civil related. They have someone has died, or more recently, increase in guardianships of adults as our population ages. They have to come to the court to be able to get jurisdiction over an adult family member. Generally, it's a family member, and generally it's an adult, not always, but those are very trying times for these people. And when it's difficult to get help to have it happen, it's a very frustrating experience for folks. And in the past, when we had a register of probate on site, and in the past when you could go into the courthouse, and in the future you will be able to go in again, we could talk to a person who could help us. Now, if you could go into the courthouse, and in 2 years ago when you could, when the probate records all went electronic, and you'd have to go into the courthouse, and if you went in, you would be told, well, over there's a computer in the lobby where you can use that computer. There's some written instructions there. And if you have trouble, you can call the 855 number and they'll help you. And that's as much human help as up close and personal help you got. These issues are sometimes private issues. They're emotional issues. There's no privacy in the lobby to discuss these very important family issues. So it's difficult for people to get the help they need. New Hampshire has what we call supervised probate, which is a more difficult process than many states have. Our neighbor Maine has unsupervised probate, and it's very easy to accomplish. New Hampshire's is a little harder. And as we have decided to keep it that way, you folks have decided to keep it that way, I think that people deserve to have the help they need to be able to work their way through it. So the last thing I'd like to say is that this bill, the funding issue in this bill has been to use some of the court filing fees. And I know the court, is always careful with their budget and cares, and would be unwelcome to have them not have some of their fees go to everything they want it to go to. But New Hampshire, in relative to other states, has some of the lowest filing fees in the country. And I think that when we have a process that requires people to jump through a lot of hoops, we need help to have them jump through them. And I think it's money that has to be spent to provide the help that they need. I heard somebody say that in the bill, the access to the computer system of the court is denied. With all these records being electronic and on the computer, I think it's really hobbles the effect of the register if they're not at least having view only. I wouldn't suggest for a minute that they have ability to change what's on the computer, but I think they should have a spot where they can see everything, all the data that's on the computer about a case if they're trying to help a constituent with that work. Having said that, I will welcome any questions you folks might have of me.
Any questions from the committee? Senator Ward, do you have a question? Oh, okay. All right, seeing none. Thank you, Jane.
All right, and our next speaker is Richard Head.
All right. Welcome.
Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. First, I just want to, on behalf of Judge King, who's the administrative judge of the Circuit Court, apologize. He was unable to make it today due to a conflict he was unable to get out of. And I also wanted to express my appreciation for Senator Gray and the conversation we had on Friday. He spent a decent amount of time with me talking through his goals of the bill, which was incredibly helpful. And really what I wanted to focus my testimony on this morning is how I think the bill, Section 5 of Senate Bill 89, goes beyond what he's actually trying to accomplish and creates some significant issues, which I think may have been unintended, but maybe in the drafting, some issues were created unnecessarily. And at the end, my recommendation is that Senate Bill 89 be amended to strike Part 5. And we're happy to work with Senator Gray over the summer to see if there is a role along the lines of what he was talking about that we can agree to relative to essentially having registers of probate assist with the filing and getting people through the electronic filing process, if that is the goal. But I do want to highlight some issues and some significant concerns we have with Part 5 of Senate Bill 89 as drafted. And I'll be referencing section numbers, but I can also, if it's easier, reference page and line numbers. But Sections 1 and 2 of Part 5 deal with the establishment of salaries. We have no particular issues with that. The salaries would be set by the counties. What is less clear is exactly how payment of those salaries occurs. And it's a minor issue, but it's significant in the grand scheme of things in that it's not clear if under the language of the bill, if the counties are actually paying that salary and the counties are then being reimbursed by the fees that are discussed in Section 12. Sections 3 through 6 of the bill. And as I understand the bill, the salaries would be set. The sections 3 through 6 would require the courts to adjust the filing fee to account for those salaries. Unclear sort of just that process, how that works, but and then those fees, the 10% of the fees collected would be deposited into a fund that would be used to pay the registers of probate. Unclear, at least as written, whether we're reimbursing counties or if that fund is then to be drawn down to actually pay the salary and benefits of the registers of probate. Also, just in terms of liability for those salaries, if for whatever reason that fund depletes and there's no money in that fund, it's unclear in the bill as to who has the liability to pay those salaries and benefits, if it's the county or the state. But essentially the fee would be a predictive fee in anticipation of what the registers of probate salaries would be. The bill also talks in sections 7, 8, and 12 about the role of the clerks. And currently, as what I think you've heard of testimony on, in 2011, the circuit court system was created and created 3 divisions within the circuit court, that being the district division, the family division, and the probate division. Those 3 were formerly separate courts under a unified court system. And in 2011, they were brought under the circuit court and created as divisions, with the circuit court clerks being given the roles that formerly had been with the district court clerks, the family court clerks, and the registers of probate under the probate court. This bill sort of oddly changes the role of the clerks in section 7, which is page 6 of the bill, and strikes, so and modifies RSA 490 F13, where it says circuit courts, and this is line 28, circuit court clerks shall have the same duties as clerks of the former district court. And then it goes to strike and judicial family division, judicial branch family division, and as registers of probate. One, I'm not at all sure why family division was struck, but then 2, it strikes registers of probate, which I think results in clerks no longer having a role over probate court, if that is just struck in its entirety, leaving clerks with the same duties as clerks of the former district court only, as the bill is written. Even if the family division was an error and it should be just striking the registers of probate, again, we're taking out the clerks from the role on the probate division, and really very unclear as to then who has any role relative to the probate division. The other aspect of this is along the same lines of who ultimately has management and oversight of the probate division. Section 12 of the bill, page 7, says that pursuant to the New Hampshire Constitution, the elected, and this is a new section in 548 under the bill, it says, pursuant to the New Hampshire Constitution, the elected register of probate shall have access to and oversee the filings of the probate division. And I just note one, that the Constitution actually doesn't describe the roles specifically. It leaves that to the legislative branch, and the legislative branch has in fact defined the roles of the registers of probate relative to historic documents. But here it says they shall have access to and oversee the filings of the probate division, which strikes me as a much more significant role than what Senator Gray described in his opening statements relative to Part 5. And so at this stage, it appears that we have oversight, which is a managerial role of the registers of probate in the court system. And, we have some concerns, and it also provides, by the way, that in that same section, as you heard earlier, that the registrator of probate shall have an office either in the county or the probate court in the county in which they were elected, and the register of probate shall have read-only access to all probate records. So, and as I heard Senator Gray, really what he was looking for was access to the records of a particular constituent, not all. And by giving access to all, we are in a situation as a court system where we are giving essentially complete, albeit read-only access to a area of practice that has a great deal of confidential information within it. And by providing sort of open access, albeit read-only, and also providing that registers of probate, as in the bill as written, have a managerial role overseeing the filings, that we have an elected official who is tied to the county and not a court employee, who's not subject to the court practices and procedures, not subject to the court's policies, and is not subject to either discipline or evaluation by the court system. And we have no ability to terminate or otherwise, in an employment situation, provide any sort of managerial oversight. And we don't do background checks on registers of probate, that we're giving them really a great deal of access to court records that are highly confidential. And it is not well described within the bill as written as to what that means. So we have some significant concerns relative to that role. And again, it seems beyond what Senator Gray was talking about, which is helping people navigate the electronic filing system as sort of an essential role. And access to filed cases really is not necessary. What we would be talking about is really helping people navigate that electronic filing system. I'll also note, though, that registers of probate have no criteria for being eligible for that position. So whether or not they are themselves qualified to be able to do that is, determined, is not an element as to whether or not they've run and ultimately are successful in becoming registers of probate. I will note that Senator Gray's bill does have the provision for a deputy register of probate, so that if the county is in a position where the register of probate is not himself or herself qualified to sort of have this role of assisting people, that there'd be a deputy that could oversee it. It's in that it sounds like, although again it's not entirely clear, that the deputy would assume the salary of the register of probate. And that in and of itself can create some conflicts. It's also unclear, and I think this needs to be very carefully considered, as to how do we ensure that a register of probate is not straying into giving advice, because then you create issues of liability. And then the other part of that question is whose liability? Is it the county's liability or the state's liability? If in the course of assisting somebody with the electronic filing, they say, oh, you don't need to do that, or you don't need to file that, or you don't need to give them that information, does that one stray beyond what is being contemplated by this bill, or is that within this bill? And really, how do we define that line so that a register of probate is not straying into providing advice as to how they should be filing, or what information they need to be providing, or telling them that they don't need to file at all when in fact they should be filing. And it just becomes a little bit unclear in terms of what that means. If going back to the fees, and I apologize for jumping because I forgot about this, if the fees are just supposed to be 10% of what we are currently collecting, 10% would be about $130,000, which I put in our written testimony. And that one, I don't know if that would be sufficient to cover the fees or the salary and benefits of registers of probate. And I would imagine that would ultimately come down to how many counties are going through this process, because it sounds like it's entirely a process that's decided by the counties as to whether or not they would actually undertake this role for the registers of probate. But if in fact it's reducing from current fees, then we would essentially be taking from some other funds. Currently, the fees go to court facilities, goes to our IT fund, and goes to the general fund. And if the reduction was split evenly, there would be reductions in those three, which could potentially cause the judicial branch to need to draw further from the general fund, if in fact the monies that were necessary to fund IT and court facilities was not sufficient after reducing for probate fees. So I think my overall message is I appreciate and understand, I think, what Senator Gray was seeking to do in this part of the bill, which struck me as a fairly straightforward potential role if it's really to help somebody navigate the electronic system. I am somewhat concerned that given the volume of calls that come to the call center, and to the call center's credit, we get a great deal of compliment regarding that process. It is highly efficient. It is, and not all these calls, take the full amount of time. Some are simply saying, "Did you get? Was this on file?" Which is absolutely appropriate. If the clerks are no longer holding a role, though, if the clerk's role is diminished to the district division and family court, assuming that is fixed, what is the call center's role then relative to probate? And what is the role of the registers of probate? and how is that being communicated? And again, these are things that I think need to be carefully thought through. They need to be considered and they need to be done right so that we are really not creating problems that are not intended by Senator Gray in this bill. So I do ask, at least at this stage, that this be amended to strike Part 5, that Senate Bill 89 strike Part 5, and that, I'm happy to work with Senator Gray if there's a limited role that along those lines. Happy to work with him without, at this stage being able to commit that we would be able to successfully agree to a specific role. But I think once you get into saying they are overseeing the filings, giving access to highly confidential records, and being able to set policies, which is another section of the bill, of relative to probate, I think we're creating a greater role for registers of probate than perhaps Senator Gray was intending. And with that, I'd be happy to answer any questions. Thank you very much for giving me the time this morning.
Thank you, Attorney Head. Any questions from the committee? Seeing none, thank you.
Thank you.
The next speaker is Raymond Tweedy. Oh, he looks like he put his hand down. All right, if anybody else would like to speak on Part 5 of the, okay. Anyone else would like to speak on Part 5, please raise your hand now. I'm going to bring in Raymond Tweedy. And I'm getting some kind of notice that Mr. Tweedy is using an older version of Zoom, so I can't bring him in. Mr. Tweedy, I would recommend calling in by phone. I've never seen this warning before. We can circle back to you. The next individual who has their hand raised is Paul Mirsky.
Can you hear me?
We can. Welcome.
Well, this is very pleased to offer some testimony. Thank you to the chair and the committee for willing to listen. I was in the legislature in 2011, 2012 when the Register of Probate Office disappeared. And I was completely unaware of that until about 2 or 3 years later. When I was astonished to learn that the court, during the budget proceedings in 2011, convinced the leadership of the House and Senate to statutorily gut a constitutional provision, the constitutional provision for the Register of Probate, which existed primarily to ensure transparency with regard to probate proceedings. I'm not going to speak to any aspect of customer service, which I think that there are others certainly once we're able to nominate, especially Jane Bradstreet, which I think is absolutely essential, a feature of this, because it goes to transparency. But for the court to have actually engineered the destruction of this constitutional provision when its role is to really serve the intent of the Constitution is really astonishing to me. And I still haven't quite got over that. Excuse me. I do have some trouble breathing and I have a little trouble getting my words out sometimes. So I'm very interested in seeing to the restoration of this constitutional provision. When I sat on the Judiciary Committee as a member of the House in the 90s, the justices who would testify would come in and they would always introduce themselves as a member of a co-equal branch of government. And that, in fact, was, I later learned upon reading the Constitution, paying attention to what it actually said, was a fraudulent statement, because when the founders wrote the document, they did not provide for 3 equal branches of government. They provided for a very powerful legislature, a very weak governor, and for a judiciary, which was entirely under the oversight of the House and Senate. And the reason for that was that under the English system, of course, if you weren't tied into, basically the judiciary served the king and the privy council. So if you didn't have influence with either anyone in that sphere of governmental activities, your chances of getting justice in the courts were pretty slim. So when they wrote our Constitution, they made sure that the judiciary would have significant oversight. The Constitution gives the judges essentially life tenure subject to good behavior, but it gave the legislature the capacity to look over the judge's shoulders, and if they found misbehavior, malpractice, etc., they provided a couple ways to remove them, by address and by impeachment. Because, well, for obvious reasons, they didn't want individuals to be mistreated. Now, with respect to the courts, in the 1880s, there was quite a dust-up between the legislature and the judiciary that resulted in numerous judges being removed by bills of address, the restructuring of and reappointment of the judiciary, reappointment of judges. And that particular episode, in my view, having watched these proceedings for a long time now, that particular episode really set in the judiciary, members of the justice's mind and other members of the judiciary, a desire to somehow get out from underneath the oversight provisions of the Constitution that the legislature had. And it wasn't until the 60s and 70s that the bar was able to promote, I think, 3 constitutional amendments, which substantially diminished the legislature's ability to oversee what was going on in the judiciary. And they managed to make it much more difficult to remove judges by bills of address and so forth. And they elevated the status of the judiciary in the process. Then, of course, we were followed in the 80s and 90s with some atrocious examples of judicial malpractice, or malfeasance, rather. And I was appointed to a committee at the time that to look into some of that. And
Mr.
you
Mursky,
begin to realize how important it is that there is a
Mursky?
reasonably
Can we
easy.
get back to the Senate Bill 89 Part
Okay,
5?
you're right. No, you're right. I was just what I was trying to get to was the point that oversight is essential. When Willie Sutton was asked why he robbed banks, he said, that's where the money is. And if you want to think about it, probate is where the money is in New Hampshire. There are billions of dollars, I imagine, in estates that transfer over time from one generation to another. And if no one's watching the store, how is there any capacity to prevent malpractice, malfeasance, theft, etc., in that process? So my interest in running for the office and serving as the Grafton County Register is primarily to promote the restoration of this office. I mean, it's naturally understandable that Mr. Head would oppose Section 5, because that's exactly where Section 5 is intended to go eventually, is to provide some way to watch what's going on in the probate offices, to ensure that individuals who have their estates in probate are taken advantage of. And we know for a fact that sort of thing has happened in the past. And right now, there's really no way. The court is operating behind a shield, and the people's elected representatives really can't penetrate it. So I want to encourage the passage of Section 5 of this bill in the interest of restoring the office and being able to improve the way that individuals may be treated in the future. Thank you.
Thank you so much for your testimony. Any questions from the committee? Seeing none. Again, thank you.
All right, and on my sign-in sheet, I do have someone under the name Luz Bay. I don't see this individual on the list, so if you could please raise your hand if you are on this call virtually, or if you want to press *9 if you're calling in by the phone. But I'm not seeing this individual on there. We can try to circle back to Mr. Treaty again, see if he sorted out his technical difficulties.
Sure.
Good morning, Kirsten. Sorry about that. I switched to my phone from my Chromebook, which is relatively new. Kind of ironic considering my testimony. Luz is the Register of Probate in Stratford County, and she had to leave the meeting at 10. So unfortunately, she wasn't able to contribute. For the record, my name is Ray Tweedy, and I live in the town of Rye, New Hampshire. I am the Rockingham County Register of Probate. I was elected in 2018 and again in 2020. In 2020, there were 178,388 votes cast in Rockingham County's 37 cities and towns, and I was honored to win 94,857 of them. Before you today is Senate Bill 89, part of which restores some duties and responsibilities to the Office of Register of Probate beyond what exists today. I support this effort wholeheartedly. In fact, before you today are a group of 9 of the 10 registers of probate, 6 Republicans and 3 Democrats who believe in this bill. We are not only a bipartisan group, we represent 90% of New Hampshire's counties in this process. Overall, Granite Staters cast 633,279 votes for someone to represent them as Register of Probate in our entire state. I'd also like to point out and thank our friend and colleague Jane Bradstreet for taking the lead in our group and speaking before you today. In 2010, our state faced a budget crisis, the likes of which no one has ever seen. Some of the great senators seated here today were part of the legislature then, and they remember this all too well. The state was facing an $865 million budget deficit. Cuts had to be made. A plan had been in place for the Officer of Register of Probate that was to be a much slower 10-year process. That process was fully accelerated due to these large and looming financial considerations. In the place of many of the duties which this bill seeks to restore for the registers, a hotline was created, as well as a kiosk created in the county spaces for probate issues. My colleagues have mentioned to you previously about some of the issues that have come up with probate over the years where these solutions did not fit well. I would like to say I think that the court system overall did a Herculean job of putting together a system to keep our courts functioning in light of large budget cuts. Probate, however, is, as Senator Gray would probably agree, a very different animal. Most people don't plan for issues such as probate in the grand scheme of life. It can be said that we are too busy living to think about dying. It can also be a sad, trying, and emotional time for those who are left behind. The changes made a decade ago overlook some important issues that I've come across in my talks about this office and this bill with my constituents and attorneys in my county. The biggest issues could fall under an overall header called literacy, and there are 3 parts to that header. One is actual literacy. I have heard from clerks who have had to help folks who could not read or write. Another piece of that literacy header is computer literacy. Our state is an older one, and there is a portion of our population who did not and who do not regularly use computers in their lives, which makes all electronic filings very hard, if not impossible, for some to do. And the last piece is financial literacy. It's not knowing and understanding what to do with a person's finances and what kind of obligations there are or may be. Now, the answer may just be a simple one: hire an attorney. That is not always easy and is certainly cost prohibitive depending on the size and nature of one's estate. Our constituents need help with sometimes just filling out the forms and getting generic advice on how to piece things together in a time that can be emotionally trying. I've heard from many people not happy with not being able to go to the county courthouse to sit in a private space and have a private conversation about a lost loved one and their estate. The 2020 census shows that New Hampshire is graying quickly, faster than many other states. So these issues will come up more and more as time passes on. This bill seeks to remedy some of those situations. I would like to say I think that the bill was incredibly well written, and I thank Senator Gray for that. And what I mean by that is that the bill creates flexibility within it that allows each register and county delegation the ability to work on its own solution to the problem while maintaining consistency across the board, especially with respect to training. We can tailor the office based on the needs within our individual counties, as no 2 counties are exactly the same. I understand that the judicial branch of our government will be opposed to this bill. They are already on record as such. His Honor Judge King has even advocated in the past removing our office from the Constitution. This bipartisan group of registers, 6 Republicans and 3 Democrats before you today, disagree with that premise. We think local elections, local control, and more transparency, coupled with better and more personal constituent service, is the way to go. More than 633,000 Granite Staters agreed with us. 10 pairs of eyes and ears are better than one. The issues that the judicial branch brings forward regarding confidentiality and filings can be easily addressed by proper training, as well as non-disclosure agreements, etc. I am a banker and I've been in the banking business for more than 25 years. I keep my clients' confidences every day. Certainly, the judicial branch, upon passage of this bill, can work out these details instead of making them reasons to strike out this much needed language. I urge the division to work with Senator Gray and the legislature in a positive way to move forward. We thankfully, and even considering the COVID crisis we now face today, are not in the budget crisis we were in a decade ago. I am sure His Honor and his team can work with the legislature to replace any lost revenues from this budget that would be transferred to the counties for the purpose of funding these 10 very important constitutional positions. Granite Staters in 2020 have spoken loudly and clearly. They want local control restored to this office to enhance customer service. And one of the great many reasons to live in our state is we have the ability to change course every couple of years and fix deficiencies like this one and move forward. Thank you for your time, consideration, and allowing me to offer my testimony today. I urge you to move forward and support Senate Bill 89.
Thank you. Any questions from the committee? Seeing none. Thank you, Ray.
Thank you, Senator.
And I am seeing Jane Bradstreet's hand for a second time.
Okay, at least when I'm chairing, the second time is limited to 3 minutes.
Easily done, easily limited. I just had one thing to say, that the court testified to confidentiality issues. I want to bring up that all estates, all information in estate records is public. You would have to get a court order to make it confidential. There are some other areas in the jurisdiction of the probate court that are confidential, but those are clearly designated within the court data system, and you only have rights to those if you've been trained and know what to do about it. So I know that the bill issue brings up the issue of training, and I think that training is key. You know, before we had an information center, we had no organized training per se. A new employee would go to the court, and the clerk and the other employees of the court would train them how they wanted them to do the business. Now we not only have organized training for court information center employees, but we have organized training for all court employees. Now they've got a training coordinator. So training is a key issue, and I know that the court can provide some organized training for new registers when they're elected. That's all I have to say.
Thank you, Jane. Any questions from the committee? All right, thank you.
Thank you.
And now I'm seeing Richard Head just raise his hand for a second time.
Again, bring him in, and he's limited to 3 minutes.
Thank you again, Richard Head. I appreciate the time limit. A couple points I wanted to make. One is with regard to training. Again, these are not court employees or state employees. Normally, we have an ability to review, evaluate, and determine qualifications. That is not the case here. The issue also applies with regard to, there is access to confidential information, and how that is treated is outside of the control of the court system, where the register of probate is not, a court employee is not subject to review, evaluation, or background checks. I have no doubt about the commitment of the current registers of probate, but they are not in a position where we have any ability to put skill sets before they run. And finally, the issue of what the voters have decided is, relative to the current roles of registers of probate. They ran based upon current roles of registers of probate, and those roles are not defined in the Constitution. It's defined legislatively, and that was done when we established the 2011 Circuit Court system, where there is an oversight by the Circuit Court, by the Circuit Court Administrator, and the clerks have an essential role. And the notification relative to what would be in the registers or what the role of registers of probate would be was made very clear in 2011 in the testimony that was presented to the policy committees, and that's described in my written testimony on pages 8 and 9. Thank you again very much for your time today.
Thank you. Any questions from the committee? Seeing none. Again, thank you, Attorney Head.
Senator Birdsall, I'm now seeing Paul Mirsky raised his hand for a second time.
Again, he's limited to 3 minutes.
Hey, I want to speak to oversight again. I think that when Attorney Head speaks about the judges overseeing their own activities, that doesn't serve the legislative intent for having a register of probate in the first place. So secondly, one of the things that I thought was good about the changes that have been proposed for the reinstatement of the office was that it was more divorced from the court rather than being captured by it, which is in the public interest, quite frankly. So I just want to make those observations, that I think that the bill is going in the right direction. And again, more oversight, the better. Thank you.
Thank you, Paul. You were actually under a minute. I appreciate that. Any questions from the committee? Seeing none. Thank you.
And Senator Birdsall, I'm not seeing any more hands.
Okay, then I will take the opportunity to close the hearing on Senate Bill 89 and hand the reins back over to Senator Gray.
Well, thank you. It is sometimes very difficult when you're presenting a bill to then sit back and just listen. But I always learn a lot when I'm listening, whether I'm on the committee or not at the point. Okay, are there any comments from any of the members before we go into executive session? Seeing none, do I have a motion?
So moved.
I have a motion. Do I have a second?
Second.
Second. I'll call the roll. Senator Birdsall.
Yes.
Senator Ward.
Yes.
Senator Susie.
Yes.
And I don't see Senator Rebecca Perkins Quokka right now.
Mr. Chairman, if I may, she is coming back. Her prime sponsored bill is just being introduced right now in Ways and Means as we speak.
Okay, I just wanted to make sure that she was that we knew what her status was. And the chair votes yes. We were in executive session. I guess the first bill that I would like to take up is Senate Bill 52, relative to the charter provisions for tax caps.
I think we already talked about this, but I did talk to Derry, which has a tax cap, and they didn't, my recollection is they didn't feel that it would impact them at all. So they're neutral on this.
Okay, Senator Susie, you were going to ask the people in Manchester?
Yes, I didn't get back any concern from them, but as I had stated previously, I find the issues raised to be issues focused primarily on Nashua and issues that the existing language of the statute could fix if they went back to the ballot. So I just don't see any need for this legislation.
Okay. My comment on that is through the research that I did, it looked like the fix that we tried to do for Manchester in 2011 actually is part of what the courts cited as the problem now with the Nashua one. And so it certainly, I am not interested in going back and re-legislating things on a consistent basis that we've done before. But it appeared to me in this case, we caused the problem. That Nashua's tax cap would have been found constitutional and would have been found acceptable before we did the change in 2011. Now, is that a legal opinion? Of course not. I'm an engineer. I'm not an attorney. But that is why I was so interested to go to Rochester, my community, who does have a tax cap, and listen to the others. Nashua is a little different. It's not a tax cap. I believe it's called the spending cap. But those are my reason for pursuing this thing. So if Senator Perkins Coca is going to be back with us, we can continue any discussion that we have right now. But I probably will try to defer till when she gets back to take a vote. I think that that should afford her an opportunity to make any other comments she wanted. I guess while we have the rest of us here, if I go back to your bill, Senator Susie 47, we've taken all of the legislation now that our Senate bills, and certainly we have some overlap in here. And certainly, since I'm the author of some of the competing legislation, I certainly do prefer the way I've written it. But that's natural. Again, speaking personally, I find it problematic to have no fault absentee. Okay, you and I have talked about briefly about the Constitution, and that the Constitution of New Hampshire specifically talks about 2 reasons for absentee ballot. That over the years, if you look at the issues that have been brought before us, infirm individuals, we certainly, when that was brought to us, we certainly took that one and certainly made a citation in the law to make sure that they were covered. We were asked about that single mother who was caring for her children and unable to leave the home. If it's a family with 2 adults, certainly one adult may have the only car that they have and not afford the spouse that is at home the opportunity to get to the polls. And so we took care of that one. We certainly made a carve out in there that for employment, it didn't have to be paid employment. You could be caring for your children. You could be caring for an infirm adult. You could be caring for some other individual, even if you weren't getting compensation. So, I made the statement probably a year or 2 years ago that, please, somebody tell me who would meet the Constitution definition of why you should get an absentee ballot that we're not covering. And no one has gotten back to me with any of those. And certainly anyone, I'm certainly willing to listen to any of those. But I do not agree with, I may have to wait 10 minutes in the line or whatever. And I prefer to go today instead of tomorrow. Those to me are not reasons that I support. So that portion of your legislation that talks about basically no fault absentee is something that I can't support. So I'll give you or anyone else, time to comment on that, at least that portion of it, if not the rest of it.
Sure, I'd be happy to. First of all, with respect to the Constitution, I think some of the examples that you've given, and I would certainly add the issue of religious observances, are reasons that we've found that would allow people to vote by absentee because of observances and other things showing up on election day. Regarding the specific language in the Constitution, Mr. Chairman, I don't think it's a bar on other reasons. I think it's a floor. So I don't think it caps who can participate. I think it's at the time the Constitution was crafted reasons, but I don't think it limits us. With respect to our most recent elections during the pandemic, we found ourselves in a very awkward situation, right? I mean, we certainly, I think all of us on this committee, I know all of us on this committee believe that every eligible New Hampshire citizen has the right to vote, and we want to make sure that people can exercise it. So, we came up with legislation and allowed people, because of the pandemic, to vote by absentee. And I think that process in and of itself demonstrated that there are a number of people that may or may not in the past, because of concerns of the language on the affidavit, may or may not have exercised their right to vote because they weren't sure. But for sure, the process worked, and the process worked really well. And I think for a number of people throughout the state of New Hampshire, as they contemplate tomorrow and town meeting, I think a number of people once again said, I don't feel comfortable. I don't know how many people are going to be at the polls. The pandemic is yet another reason. I haven't been vaccinated yet, what have you. I want to exercise my right to vote. There's nothing more important than local elections. People don't always recognize that, but I think those of us sitting here know that the local level is where a lot of things happen and have direct impact on you. So I really believe strongly, and I have not always felt this way. I have come to this conclusion that allowing people to vote absentee is a way to ensure access to the polls. And I think in particular, this last election showed us how important it is to people, how being sure that something doesn't come up later on and cause them to be unable. I know you said, Mr. Chairman, waiting in line for 10 minutes. It could be waiting in line for an hour. It depends on the polling location, depends on the time. But I think allowing people the opportunity to exercise their right to vote and to always affirmatively have the individual affirmatively try to exercise their right to vote is important to me. I certainly, I don't want to go down the rabbit hole of even discussing mail-in ballots because I know people have objections to that. I think certainly our Secretary of State does, and I understand that. I just believe that someone who wants to exercise their right should affirmatively have the opportunity to do so. And I think given our experience in this last election cycle, now is the time to continue to afford that opportunity to New Hampshire residents.
Just to bring Senator Perkins Quokka up to speed, we started out by talking about Senate Bill 52, but we deferred the vote on that until you return. Right now, we're discussing Senate Bill 47, and I've spoken, and Senator Susie has spoken. I do believe that you had an amendment to 47, Senator, you didn't talk to.
I did, Mr. Chairman, and it was response to testimony that was provided. I'm looking to see if I have it in my binder. I can give you the number real quick.
I have the number if you want. It's 0371S.
Thank you, Trish.
Sure.
The amendment was very simple, Mr. Chairman. It addressed the issue that several of the clerks raised about not needing to have the ward specified, that it actually caused some confusion on the part of the voter, but that it in no way impeded the clerk's ability and the moderator's ability to process those ballots. So that's what the amendment would do.
Okay. Anyone else would like to speak on this bill?
I'll just say that from my years on election law, I mean, we have opened up the absentee ballot to pretty much make it almost at will. But I mean, it's illness, disability, home care for mothers, and work arrangements, out of town arrangements, and in what happened this past year with COVID, we were able to, we found that we can work and be flexible enough to be able to handle something like this. So I'm happy, personally, I'm happy with the way the absentee ballot system is working at this point. So that's where I stand.
Okay. Senator Perkins Quokka.
Yes, sir. Thank you. I just wanted to say that I support this bill fully. I think as we continue to transition to a more and more modern electoral system, I really think this bill is heading in the right direction. I think last year we saw unprecedented turnout, which is the goal of everybody conducting elections. We saw a safe and secure election, and I do think we have opened it up, and I really appreciate that. But people are honest, and they are always concerned that they're going to get an absentee ballot for the wrong reason, or they're going to check the wrong box. And I think just providing them the assurance that they can vote how and when makes sense for them is just another way to improve our election system. Even things like commuting to work can make voting really difficult for families. You know, in Portsmouth, for example, the polls don't open till 8 and they close at 7. By 8 o'clock, you're on your way to daycare and probably to the office. You know, you get home at 5:30 or 6. You're trying to put dinner on the table. It's bath time. Kids have to get to bed. It's hard to make it to the polls at 7. So, you know, it's not to say people don't make the effort and they don't prefer to vote in person, but I just think it's a great improvement, and I'd love to see us support it.
I believe, Senator Perkins Quokka, that you would be covered under the statute that we talked about, care of children and care of whatever in the law and the change that we made, what was it, 2 years ago, or maybe even 3 or more years ago now, for the example that you gave.
The commute issue is covered as well.
So again, you know, we really did try to expand it as far as we could without, and I see Senator Ward has her hand up. So.
We're talking about absentee ballots for the general election. There are people who have issue with town meetings. They are so disabled that they cannot get to the town meeting and they really like to vote. And there is no provision that they can vote over Zoom, for example, we have right now. When I first came to the Senate, I was told that if I was ill and needed to go down to the nurse's station, I could listen to the discussion, but I couldn't vote. I had to be in place in order to vote. So I think it isn't just a general election. There are a lot of issues that have to do with the ability to vote and under what circumstances you may or may not.
The bill right now does not do anything like that. It would need to be re-referred at this time because I don't know that there's sufficient time to take on a new issue. And since the town meeting hasn't been discussed previously, we might even, to make it germane, we may even have to have a new public hearing to include town meeting issues on this particular one. Certainly be open to guidance from our former Senate president on this. But if we are going to expand it to that issue, then probably a re-referral would have to be done. But I don't know that that would get you any further than just submitting a bill for next year in that process.
Yeah, I wasn't planning on, I was just saying there are other circumstances where your ability to vote is somewhat hampered. So this is not the only one. It's just a lot of times.
All right. The conflict that I have is I don't mind, the portion of the amendment that strikes the ward information out of but I can't support the rest of it. And we may be able to do something with the ward information somewhere else. So that personally, I guess I wouldn't mind seeing the probate issue if we took the things that are in this bill right now and removed them and put the probate issue here, allowing us a bill that we could re-refer, but certainly I would defer to the prime sponsor on that before I would do any such thing.
Respectfully, Mr. Chairman, I would prefer not. I'd prefer a vote on this bill based on its merits. I definitely think we do need to have some discussion about the probate issue and perhaps find another instrument, but I don't think this bill is the right instrument for that.
Okay. Further discussion before we start voting? Okay, first thing would be a motion on the bill itself.
I move on.
I knew right now.
Senator Birdsell, I think I saw you start to talk first.
Sorry.
You had a motion?
I move inexpedient to legislate.
Do we have a second?
I'll second it.
Okay, further discussion? I'll call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
No.
Senator Perkins Quokka,
No.
and the chair votes yes. And is there anybody that wants to take that out?
I'll take it out.
Senator Birdsell.
Okay.
Moving back to Senate Bill 52, there was a brief discussion about that. I don't know if you have any comments you want to make before we accept a motion on that, Senator Perkins Quokka?
No, sir.
Okay. Do I have a motion on the bill, Senate Bill 52? Chair will move ought to pass then.
I'll second.
We have, all right, we have an amendment, I believe.
Yes, 0447S.
Discussion on the amendment? Seeing none, we'll call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
No.
Senator Perkins Cuoca,
No.
and the chair votes yes. And now the ought to pass motion as amended.
Senator Gray,
Yes, ma'am.
sorry, could I just have I need somebody to move the amendment and second it. I just need that for the record.
I thought I did. Okay. The chair will move the amendment.
Okay,
Anybody want to second it? The
I'll
amendment.
second. I'll second.
okay. Thank you.
Does there anybody want to repeat the vote? Seeing nobody that wants to redo that, we will go to the ought to pass motion as amended.
Mhm.
For the discussion. Okay, I'll call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
No.
Senator Perkins Cuoca,
No.
and the chair votes yes. And I will take that one out.
Okay.
All right. I guess the next one is either 87 or 88. Ruth, are you, excuse me, Senator Ward, are you ready to talk about 88?
Sure.
Okay.
We have the amendment for 88. No, I'm sorry. I have 83 here. Let me get 88.
Okay, Trish, I think you've got the amendment numbers for 88.
Yep.
Yes. Let me just pull that up. Sorry about that.
0504S.
Thank you, Senator Ward.
Okay. So this is amendment to the part three, yes. From starting off with a very simple thing, a couple of words being changed. It ballooned out to a much bigger issue. And the amendment here is quite extensive. It talks about not only about where's the time limit on the RFAs from 2 months to 30 days, and providing definite addresses for any location of these served or unserved areas. But it also became, as you heard, this gentleman from Benton wanted county and communications district included. So that's happening here. Now, the very last part, of who is going to maintain the lists of these, the people who are interested in receiving requests for information. And originally, we had thought that the Department of Business and Economic Affairs would do it. But further checking around, the Office of Strategic Initiative will be the entity responsible for receiving requests for information and maintaining that. So I'm hoping that we can just do a committee amendment to change on, I have page 2, line 7. I'll change the Department of Business and Economic Affairs to the Office of Strategic Initiative.
Okay. That's on the, you said page 2, line 7, is that right?
Well, that, yeah, on the amendments.
Okay, on the amendment.
where it says, you don't have the amendment, the Department of Business and Economic Affairs shall maintain a list by town of all providers interested. Is that where what you need to change, Senator?
Yes,
Okay,
from the Department of Business and Economic Affairs to the Office of Strategic Initiatives,
OSI, okay.
OSI, right?
we'll make sure that Trish has got that.
I have it. Thank you.
Okay,
Mr. Chairman,
yes, ma'am.
we also had an amendment that Senator Khan had submitted.
Yep,
That was 177 or something.
117, 177. Yep, that
Yeah,
had to do with the specific addresses.
I'm just
And I-
trying to do a quick compare to see if we need both.
As best I know, Senator Ward's amendment takes care of the issue that Senator Khan had.
Yeah, we talked about the addresses being more specific, and also the 30 days instead of 2 months.
And you had, I'm sorry, if I could, Mr. Chairman, Senator Ward, you had spoken to Senator Khan about
Oh, yeah,
that.
sure.
Okay.
So you, Senator Ward, you incorporated Senator Khan's info into the, I see, yeah. You changed 2 months to 30 days.
Yes.
Okay. And,
and also the location to addresses.
Yes.
all right.
Okay. So, assuming that we really do have a motion of ought to pass, and then we can go to the amendment. So do I have somebody who wants to raise their hand for the ought to pass motion?
Well,
Yep.
did we, don't we have to,
Technically, we should do an ought to pass motion on the bill and then go to amendments on the bill and then back to the ought to pass motion on the bill.
Mhm.
Yeah.
all righty then.
It doesn't, to me, different chairs do it different ways, but this would be the more Robert's rules correct way to do it, I believe. So Senator Birdsell moves ought to pass. Senator Ward seconds the motion.
Second,
Now we have a motion to pass Amendment 0504S with modification identified here in the committee. Am I
Right.
correct?
yes.
And it was made by Senator Ward and seconded by Senator Birdsell.
Okay, thank you.
Are there any further discussions on the amendment? Seeing none, we'll call the roll on the amendment as amended. And Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Quokka,
Yes.
and the chair votes yes. And now we're back to the main motion as amended, ought to pass as amended.
Mhm.
And any
Move on
further-
to pass as amended.
Yep, that's already actually been done, but that's okay.
Whatever.
It's all good. It's all good.
All good.
All right. Any further discussion? Seeing none, we'll call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Quokka,
Yes.
and the chair votes yes. That's 5-0. Do we have any further motions on this bill?
Do we want this on consent?
I have no problem putting it on consent, but
All right, well, I'll move consent.
all right.
Second,
Okay, we have a motion and a second for consent. I'll call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Quokka,
Yes.
and the chair votes yes. And Ruth,
Yes.
you did the
I'll
work
take it
on
out.
that?
Sure.
Would you like to take it out?
Sure.
Okay.
Okay. I guess since Senator Perkins Quokka is here, we can go right down to Senate Bill 90.
And Senator Gray, you had said Senate Bill 87, but we still have Senate Bill 83, not 87.
Is that right?
Yes.
Well, I'll get back there in a minute then.
All right.
Sometimes I do get confused. Senate Bill 90. Everybody ready? Okay. Speaking for myself personally, I believe that RSA 91A is what the legislature lives by to provide transparency, adequate public input in the process. I've never, when I was in the minority or in the majority, had any resources of the Senate, including last year when I had questions of the Senate's attorney denied to me, when I was in the minority. And I don't know that that anyone else has experienced that. So, knowing the caliber of the people involved here and the RSA 91A's provisions, they may not be perfect, but they are what we normally conduct our business using. And that is the reason that I will vote inexpedient to legislate on this, should I be given the chance. Comments from people? Senator Perkins Quokka.
Yes, Chair, thank you. Well, as I think I mentioned at the hearing, I would just like everyone to keep in mind as we vote on this that while 91A exists and while the caliber of people involved is not on the table or being questioned, there are provisions in here that are more specific than 91A, including, for example, the requirement to hold the meetings via live stream or other digital means. As mentioned, if the changes to 91A that Senator Daniels and I are proposing go forward, that could mean that if there was a physical meeting of this committee, it would not be required to provide digital access. For example, 91A makes no provision about maps being available. And as far as resources being available to both parties, I think it's just a fair rule to have and certainly one that shouldn't cause an issue if that's how everyone intends to proceed. So I appreciate your comments and hope you will consider mine as well.
Certainly. Further comments?
Yeah, may I ask what exactly you're talking about with you and Senator Daniels? What changes to 91A are you contemplating?
Yes, ma'am. So there's a bill, well, actually two bills. Senator Daniels brought one version and I brought the other forward to make changes to 91A that would allow municipalities to preserve the right to have digital meetings after this year. And so he had proposed some changes, I had proposed some others. We've worked with New Hampshire Municipal Association to come to a final version that should be voted on soon, I believe in Senate Commerce. So, but under those proposed changes, as an example, we did not want to require that every municipal body, you know, needs to provide digital access to every meeting if they're able to have all their members present physically, just in order to avoid extra burden to municipalities. So in that case, for example, if 91A is the rule that would govern the redistricting committee, then as an example, if all members were present physically, they wouldn't be required to live stream or provide digital access to their meeting. So I'm just trying to provide an example of where SB 90 would add some additional detail to current law.
Okay, a question. If you have digital access for some people and the rest of them are actually in the physical room, you can still, whatever maps, whatever documentation you're going to provide, you can still share that on the screen so everybody has an opportunity to see what it is all about, right?
You can do that, ma'am. I do think it's important that if maps are produced, that they're shared as promptly as possible, you know, potentially if able in advance of a hearing, in order for people to be able to react to them. But yes, if digital access is provided, then hopefully, you know, materials considered at that meeting would be shared electronically as well.
So it still is available to everybody. So I don't really see, I guess I don't understand what the difference would be. If you're adding maps, other kinds of documentation, and whether you're in a room physically or watching digitally, if you still have the same opportunity for access, why do we need more specific information on 90, for example?
Yes, ma'am. Thanks for the question. So what I'm trying to make clear is that I don't believe, and you know, again, I welcome committee discussion on this. At least to date, no one has pointed out to me a place under current law where a committee would be required to provide digital access or live stream access to these meetings as the law is written today.
Okay, thank you.
Thank you.
And can I just say for the record, I'm looking at the hearing report, and in the testimony, it said that the resolutions being passed by communities, including Derry. Derry has not passed the resolution. It was, I think, a letter signed by 3 of 7 counselors, and Windham hasn't voted on it yet. It's tomorrow.
Okay, thank you for that clarification. I was intending to say that some have been passed and some are being considered, but I appreciate the clarification.
Mm-hmm.
Further comments? Call for a motion.
I move ITL.
Chair will second. Any other discussion? I will call the roll. Senator Birdsall.
Yes.
Senator Ward.
Yes.
Senator Susie.
No.
Senator Perkins Cuoco.
No.
And the chair votes yes. And I will take that one out. All right. So we're ready to go back to 83 then, I guess.
We're not going to do 89 today, are we?
I think I'd like to have a discussion about it.
Okay.
To find out where committee members are, especially the most controversial part. In fact, if you want to do that now before we get into 83, I'd be happy to.
Yeah.
What is the committee desire?
I think I'd like to get through 83 and then if we have time, do a.
Okay. So let me open up 83.
I mean, is everybody else okay with that?
Yeah, we can do 83 first and then talk about the other one after.
Yeah, that'll only leave us one left.
Certainly on 89, we're not going to be well, again, we'll save that for when we get there. All right, this is 83, clarifying the circumstances under which persons are disqualified from the certain duties relative to the establishment of the election information portal, recount fees, itemized statements, which we have an amendment which does that, and pending optional town meeting procedures, which I think we also have an amendment on that portion of it.
Yes,
All right.
you should have two amendments. One is Senator Khan has an updated amendment, which is 0506S. That's his most current amendment. And then Senator Gray's amendment is 0346S. I can send or put them up on the screen, either one if you want.
Well, before we get there, is there anyone who wants amendments or has objections to part 1? And that was getting the language in those two statutes to be similar, if not identical, so that it clearly cites when someone who is on the ballot and they are additionally an election official can serve. All right, seeing nothing on that. Moving on to 2, election portal. Any comments or anything on that? Okay, not seeing any. Relative to recount fees, certainly the amendment that's out there, and maybe you should put that amendment up. I had individuals that said that they wanted it free. And so the amendment, to refresh your minds.
Sorry, hang on one second.
It's okay.
Oops, can you see that? No.
I have the amendment.
I do too.
Could you just increase the percentage, Trish?
Sure. Do you see the amendment though on the screen?
Oh, yes, I see it on the screen. It's just.
Okay, I can.
Increase the size. I think it'd be easier for people trying to.
Yep. Sorry, how do I do that?
So if you move over to the middle where it says 100%.
Yeah, 100.
There's that plus button there.
Yep.
There we go. Okay.
Okay.
Is that better?
Okay.
Yep.
So what the amendment does is it says that if the difference is 1/4%, it disappeared, that your recount is free to begin with.
Is it back?
That's quite a small number in a large town, but again, if you're getting that small a percentage in a smaller town, it's not really going to have a large effect on anything. But again, we're certainly not discouraging people who have races that are that close from doing that. There are people who don't think I should increase the fees for the other percentages on there. Remember that once you get up to 3%, you have to pay the full cost of the recount anyway, just the way it gets billed. And that you never pay any more than what the percentage would be from the election night, but you can pay less if the recount shows that you are less. So I guess we can go back to the regular screen.
Could we get on this? Well, all right, that's fine.
If you want to see something else, Senator Susie.
No, I'll just look at it myself because
there's the bottom.
What's that?
Did you?
Yeah, Trish, it's not on the screen. You.
Oh, I'm sorry.
It out, so we lost. We never looked at the second page.
I'm sorry.
That's
Is that
okay.
better?
Yeah.
Okay, great. Sorry.
And the bottom of the second page is only making the Roman numerals match up
Okay,
words so that, you know, when you get down to the 3%, it's now in section 4 because you added the no fee in the other one, etc. But the part I wanted you guys to weigh in on is whether or not you want to raise those fees at all. Certainly that was a knee-jerk reaction on my part to raise those fees because I thought that some of the recounts, both in the state of New Hampshire and in other localities, were done not because they thought that the votes would change, but to prove a point for whatever. And again, I'm not saying that's right or wrong or other, but when the state is paying a considerable price for conducting these recounts, we need to be judicious in what we ask for a return. I don't know when the original law was that set these fees, but I don't remember changing them in the last 8.5 years that I have been serving on either the House or the Senate election law committees. So, you know, if you want them changed, there's a vehicle to do it. If you don't want them changed, there's a vehicle, you know, we can cross that out and still leave in the free ones.
Oh, my question is, when was the last time we had a recount for the president, Congress, or a senator, US? Most of the recounts are from the executive counselor on down, isn't it?
Yeah, certainly.
gubernatorial primary in, was it 90 or 92? And then US Senate, the big one was back when John Durkin and Louis Wyman. I don't recall one.
How long ago was that?
40 years ago.
Were you there?
I was not.
I voted in that election.
Oh, geez. So I'm just wondering if we haven't, I mean, I get it. And since it was, we're talking back in the 70s. So I get that we haven't had a recount. So since in what, 40 years or so. So it wouldn't make that much of a difference increasing those costs, but
Senator Susie, correct me if I'm wrong. Wasn't there a recount that was started and that after like one day that it was called off because of the cost that was going to be incurred? And that was around 12 years ago or so.
You know, that's quite possible, Mr. Chair. I just don't specifically recall, but I don't know if anyone's still on from the Secretary of State's office, but I don't.
Trish, is there anybody? Is there anybody on the call from the Secretary of State's office?
Our Senate attorney is, he may be.
Yes.
All right. If the Senate attorney has input, we would certainly appreciate any that he has.
He's not too happy with me.
Yes, no. Rick, are you there?
You tell me, am I there?
Yes, you are. Okay.
Well, I think, didn't we start an executive council race this time that stopped fairly quickly, but I don't think we've had a recount since above that line since the Wyman Durkin. I'm not familiar with another one that got started in the early 90s that I can recall.
Okay, thank you. All right, so just a straw poll from the committee first before we take any roll calls. How many people want to drop the provision of raising the fees as the amendment would have you do?
Oh, fee.
All right, I don't see anybody that says that they really want to drop them. So we'll leave that one in there, and unless somebody has more discussion on that topic, we'll go down and talk about part 4. Okay, getting down to part 4, the itemized statements filed by the political committees. There is an amendment on that also.
Here's that one. Oh, that's the one that was
The
kind of-
Senator Khan one?
Yeah.
Okay, yep, I can put that up.
Chairman, didn't you have an amendment 0564?
Yeah, that there should be a gray amendment that goes to this section. The Khan amendment is section 5.
Okay.
Right. I don't see the other one here. Maybe I'm missing it in OneDrive.
No, I don't see it either. It
But
was,
I do recall discussing or having some conversation about it. I just don't see it here.
It was distributed. I had it, I thought it was written and then it wasn't written. And then I had it written last week and it was sent to
yes.
the committee. And apparently it hasn't gotten up on the.
So it's not, okay, not that one. Hang on 1 second, I
have it as 0564.
Okay, I have them all here.
I have it.
Yeah, I don't have that.
I think I have it.
Yep.
Yeah.
Okay. I have it.
If you'd put it up, I'd appreciate it.
Yes, sir. Let me just share my screen.
This was to address Senator Perkins Quokka's comments, Deputy Secretary Scanlon's comments. If you would enlarge it, please.
Oh, sure.
Okay. If you get down to section below, all right, where line 12, is that where I did all that stuff?
Right here.
Yeah.
Yeah.
All right.
The font size and everything is right here.
Yeah, and above that, in 664,
Yeah.
I guess it was line 12.
9, isn't it?
Oh, 9. Yeah. They wanted special note made of filing it electronically. Yeah, so
Yeah.
it's line 7 on down that talks specifically to the ability to electronically file it. And then if you decide to do it by one of the other methods, then you need to make sure that the font size as printed is no less than an 8-point font. It's an email attachment in PDFA. For those that don't know, PDFA is a portable document format archive. And what that means is that the required information to print it as it was originally published is contained in the document. And that's, so the A stands for archival. And then line 3 there, the report is mailed or delivered or sent. Senator Perkins Quokka, you were the one that commented on the words I used before. Do these satisfy your desires in that area?
Yeah, I thought the language all looked good here. I did try to send you feedback. I don't know if it made it to you. The only change I thought might apply, and it's hopefully minor, is on line 25. I thought it makes sense to just add a couple words. Right now it reads, the political committee of a candidate or a candidate shall file an amended copy of such candidate's report within 1 week after being notified by the Secretary of State or Attorney General's office. I thought we might just want to add something like that such report is non-compliant.
Sure.
Okay.
I thought that I had that worded such that the above took care of it, but I'm not. I don't object to the words, the report is non-compliant.
Okay.
And again, certainly, I think we all know how intense these elections can get. And then when we're filing these reports, it is easy to not get them sorted in alphabetical order, to fulfill all of the small requirements. So without objection, does anyone object to Senator Perkins Cuoco's addition to that amendment?
No, that's a good idea.
Yeah, I'm good.
Okay,
Okay.
Yep.
And Trish, you've got that?
Yes, I do.
Okay.
Thank you, Chairman. Could I just ask one thing? I just want to make sure. Okay, so on line 18, we've clarified your original language had sending of the reports, and all of that is gone and
Yeah,
replaced with language that says it has to be mailed by the date. So as long as it has a postmark or
Yeah.
has been placed in a mailbox,
Yeah.
even though the Secretary of State's office may not receive it for a couple of days.
Yeah, I'm trying to
No, I
incorporate
think that's the
what you
appropriate.
asked for, Senator.
I'm just trying to make sure we're all clear. That's section has been addressed.
Yes,
And
ma'am.
maybe when we get to the floor, Senator Susie, we can clarify that, just the intent of the language.
All right. Any additional comments on part 4? Okay. Part 5, and that is the Senator Khan amendment.
Okay.
And
Would you like that up on the screen as well?
yes, please.
Okay, let me share it.
In my conversations with Senator Khan, he made specific reference to the ability to spend money if you haven't passed the budget, and that right now in the statutes, that if you have a fiscal year that starts in January, it covers it. But if you have one that starts later and for one reason or another, you delay your meeting, those words aren't covered. Let's see, is that in his amendment here? I guess I don't see it there. Let me go back to the original bill. And I thought I had all this taken care of. Okay, in the original bill on
Section 1.
page 4, part 5, section 1, right.
And it looks like the amendment retains that language, Mr. Chairman, and then he changes the language following that.
Okay. My desire would be to only keep section 1 and renumber section 4 to section 2, the effective date. I don't like the procedure that is in there. That's the 1129 procedure, I believe. I think it has many flaws. We passed Senate Bill 2 pretty much because of some of those comments about it. So again, the argument is okay, well, what do I do? Well, if we get to this situation before that's invoked, you need an executive order declaring a state of emergency to begin with. And as we know, state of emergency, depending upon the details of any particular emergency that we have, that may affect what you want in or what you want out of that procedure. And not liking 1129's procedure to begin with, I can't support leaving that in there. Comments from any other committee members?
Excuse me.
Because I'm not sure that I know what you're talking about, Jim.
Okay. In the original bill,
Yep.
on page 4,
Mm-hmm.
part 5, section 1, which starts on line 11,
Yep.
that is a fix that if you, for some reason, have a fiscal year that starts other than January the 1st,
Mm-hmm.
and you don't pass a budget, that you can spend to the original or the budget from the last year, make a reasonable appropriations in light of, and since we give that to the people that start in January for their fiscal year, I don't see a problem with doing that for communities that have a July start.
Okay.
But, you know, I'm certainly willing, but the rest of that and the amendment that Senator Khan has proposed, I don't agree with, because I don't agree with the 1129, which is what it was based on.
So
So-
1129 is another bill?
1129 is one of the bills from last year
Okay.
that allowed for alternate town meeting procedures.
Okay. Okay.
That is the one that allowed you to have a Zoom meeting instead of the deliberative session.
Yeah. Okay.
Then you had to have a second Zoom meeting that the people didn't get a chance to vote on changes to the warrant article. Again, it's things that I would not like to see repeated.
Okay.
So let me get this straight. This is putting what the executive order put through, or we passed in what, 1166 last year, but to cover the pandemic. And then Senate Bill 2 covers the rest through July 1st to allow towns to do this. This is putting it in law permanently.
Yep. 1129.
1129. Okay.
Everyone done with the amendment?
I think what the amendment tries to do though is deal with a situation similar to pandemic, but it says, any health or safety circumstances arising from state of emergency, but then it also has, I believe the citation is to the weather provisions. Once again, I think it's just trying to codify some of these things so that towns, just like this last time, had the governor not issued an executive order, it's just trying to give them more information in advance so that they can more orderly plan for the circumstances in a particular election. So,
and if he had included the language from Senate Bill 2 also, such that there was an alternative to the 1129 procedure, which I do object to, I would feel more comfortable in doing something. My problem is that The same thing that we're going to face when we get to Senate Bill 89 is that I can't re-refer a particular section of this or part of this bill. I either have to re-refer it all, pass it all, or ITL it all, or move it to somewhere else. So, you know, I don't like the bill 1129's procedure. Much happier with the Senate two bill procedure that we came up with from this year and past. And you know, if this is taken out, certainly Senate rules would not prohibit it from coming back, because we will not have voted against it in any manner. So it can come back next year. Comments?
Well, do we want to give it another week and talk to Senator Khan about the provisions?
Well, I have, and he would like it in there and I would like it out. And
Okay.
you know,
I just wasn't aware that that conversation had taken place already, so.
Yeah. And I believe that he will request on the floor that it come back, but you know, that is certainly Senator Khan's prerogative. If in fact the committee does vote it out, we haven't done anything with it, and I don't want to assume a vote that has not been taken yet.
If he brings it in as a floor amendment and we vote against it, that means he can't bring it back next year or next session, correct? Or no?
Well, I guess I would refer to someone who had to make those decisions last year and the year before. Personally, I would say that the way the language is in the Senate rules, that we are not bringing back the same bill, and that his words, if it included part of Senate Bill 2, would be more different than the rules would even require. So he would be free to bring it back. Senator Susie?
And technically, it would be a different bill because this bill has multiple parts. So arguably, and we have traditionally allowed an amendment to come back, so.
So do you want to take out the whole part 5?
I want to leave in
Section
lines 12 through 17. And then you need to go back down to the next page, line 37 for the effective date. And everything between those two would get crossed out.
Wait, I'm confused. I thought you just wanted to keep section 1, expenditures prior to meeting, no?
Right, but you need an effective date.
For the balance of the bill.
Oh, okay, I got it.
So
Or for the balance of.
effective date for that section is contained on line 37 of page 5. So that would become, instead of section 4, it would become section 2.
Okay, I get it. I thought you were trying to keep the rest of it in there. All right, got it.
No,
So you can make an amendment to remove the parts that you don't want in it, right?
Yep.
Senator Gray, I have a couple of questions on
Yes,
that.
ma'am.
And were you looking right then, when you were giving those numbers, at the bill or at Senator Khan's amendment?
Well, in my scenario, Senator Khan's amendment might be voted inexpedient to legislate.
Okay, so then
Or
on the,
not introduced at all.
right, okay,
It would have the same effect. And it would be up to, I guess I wouldn't introduce it, but if one of the other senators wanted to introduce it, then we would deal with it and then deal with whatever else we needed to.
okay. So when we get to the amendment part, you can tell me if you all want an amendment on the actual bill to what you were just saying.
Let me ask the question right now. Is there any senator who wants to propose a motion on Senator Khan's amendment?
I would, but it seems as though it's indicated how that's going to fare. So I think probably on the floor would be a better place to have that
Okay.
discussion.
So
Matter.
I'm gonna do this one a little bit by parts. All right. So an amendment on part 5 would be to keep section 1, and if yes, ma'am.
Sorry. Can we have a motion on the whole bill
Yes.
first and then go through the parts, the amendments, because then I can.
I would move ought to pass on the bill.
Okay.
And Senator Birdsell seconds.
Thank you. Okay.
Okay. Now on part 5.
Yes.
All right, we're going to keep section 1 of part 5, or we're going to propose to keep section 1 of part 5.
Okay.
And then we also need the effective date portion.
Which is on line 37, correct?
Yep, and that 4 will change to 2. And all of the rest of the stuff in between would go away.
Yep. Okay.
All right. And since it's mine, I will move that committee,
Committee amendment.
that section.
Do we want to keep the effective date of September 2021?
It's certainly fine with me because your Senate Bill 2 already covers them through August.
Okay.
Okay, and this would start September the 1st, so it would make sense to do that. And I guess Senate Bill 2 hasn't actually passed the House, but there is an executive order that accomplishes that same thing. So I don't know that it makes much difference what that date is right now, but if anyone would like it changed, I'd be more than happy to entertain it. Okay, so on this particular committee amendment, unless there's further discussion, I'll call the roll. Senator Birdsell?
Yes.
Senator Ward?
Yes.
Senator Susie?
No.
And Senator Rebecca Perkins Quokka?
Oh, you're muted.
No.
Thank you.
Okay, and the chair votes yes.
Okay.
Okay, so moving back.
Amendment on part 4. Do you want to take up?
Or 3.
We can go backwards, part 4. And the amendment number is
0564S.
0564S.
Mhm.
Okay. Do I have a motion on 0564S?
So moved.
Second.
Second. Oh.
Okay.
Second.
The second, I think I heard Perkins Quokka first. Okay. All right. Further discussion on that? Seeing none, I'll call the roll. Senator Birdsell?
Yes.
Senator Ward?
Yes.
Senator Susie?
Yes.
Senator Perkins Quokka?
Yes.
Chair votes yes. Okay. Moving back to section 3. And the amendment number on that is
0346S.
okay. Do I have a motion on 0346S?
Move ought to pass.
Senator
Second.
Birdsell, second by Senator Ward. Further discussion? I'll call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Cuoco,
Yes.
and the chair votes yes.
I have
All
a-
right.
Senator Gray,
Yes, ma'am.
on the amendment for part 4 that we voted on, 0564S.
Yeah.
Was 5-0. That is the one that you all agreed to add on what Senator Perkins Coca suggested, correct? At the line 25, that such report is non-compliant.
We'll call the roll on that one again because we want to highlight that that was what happened. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Cuoco,
Yes.
the chair votes yes. So yes,
Sorry.
it includes that. No,
Okay,
we
thank you.
want to make sure that we get procedure right.
I should have thought of that before. Okay.
That's fine. All right, and the other two sections, I don't know that we have amendments on those. So
Didn't see any.
now it's time to vote on the bill as amended.
Mhm.
Further discussion.
I would just say, Mr. Chairman, since we can't divide out a section, although I take issue with part 5, I do support the other 4 parts, so I'll vote in favor of the bill, but I wouldn't support putting it on consent so that we can have that debate on section 5.
Yes, ma'am. Any other discussion? Okay, seeing none, I'll call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Cuoco,
Yes.
and the chair votes yes. And it won't go on consent. And this is probably another good one for me to take out, I guess. I'm not so sure anybody else wants to. I ain't gonna.
Too many
All right.
moving parts for me.
All right, so am I correct that the only thing we have left is 89?
Yes.
Okay, so we will need a, next week we have a meeting anyway because of the House bills. I don't think the House bills are going to consume a lot of our time. But I have been surprised before. Let me open 89 again. The register of probate stuff, certainly I have been pursuing that for several years, even back when I was in the House. We have made concession after concession after concession to the courts. We have incorporated requested changes. In fact, one of the things from this version that you've got in front of you of the section here is what passed the House. I believe it was 2 or 3 years ago. It came with a list of things that the court wanted changed. I handed that list to the drafters and said, make every single change the court wants because we need to show some accommodation. I am willing to work with Mr. Head in trying to resolve some of the issues. Personally, I don't have a lot of problem with some of the things that he's saying. That in resolving the salary issues, the counties that decide to do this are going to set the salary for both the register of probate and, if they choose to have one, the deputy register of probate. They are ultimately responsible for that salary. So there should be no question about what happens if there's a shortfall. Okay. And I believe that the bill, and I'd have to go find it, But I believe that there's a provision that if they don't get the number of cases or assist in the number of cases provided, or that the salaries aren't commensurate, I forget exactly how it was worded, but that the money would be returned to the court system for their. I also want you to remember that the court system is the one who sets the fees for various things that they do. So if the court system says, well, you know, I don't have sufficient numbers to do the various things, then the court system has the ability to go and adjust those fees such that they would receive additional funds. Now, I also want to put a caveat on that, is that some of that is discussed when we do the budget and decide how much money is going to go to the court system, as I understand it, and I could be, you know, incorrect. So I don't have any problem with that. Rewording the section about the clerk of the circuit court not having oversight or review or whatever of the family court and probate, I'll work that out. Again, what I'm looking for is that an individual who with average intelligence be able to take an estate, especially one less than $10,000, and do it without the assistance of an attorney. And wherever that takes me, I'm willing to do some of the concessions. He made a comment about page 7, RSA 548, about oversight. As I remember, the reason the word oversight came in there is there are specific dates and time intervals which are in statute for various parts of the probate process to happen. And if that needs to be clarified, you know, if the register of probate is assisting an individual and there's a 30-day time limit between when the court is provided information on, say, the list of assets, the inventory, or when the court is provided the information about who should be established as the executor or executrix of the proceedings. It is important for those individuals that they be able to have and ask the question, hey, court, you know what's going on. And if we need to clarify some of that, I'm willing to do it. And read access to the files, confidential information. If we can work out a system where the individual has to go in and actually give permission, for the register of probate to be able to view their particular file, then I would think that all of the privacy concerns and all of that all go away, because that individual would have. So the question back to the committee is, where do you want to go on section 5? And what is your opinion on section 1 through 4? So if I can get back to the screen so I can see people.
Yep, sure. Sorry.
The chief election officer.
No problem.
Okay.
So this is
Prohibiting taking photographs within the guardrail of other individuals and or their ballot.
Wait, what was the status of section 1? I missed that.
I saw no objections.
Right.
Except Senator Perkins Quokka has a quizzical look on her face right now.
Yeah, I had heard some feedback about this being a residency requirement, but I don't see that. So.
Okay.
Okay, sorry, thank you.
The feedback on the chief election officer did have some comments about residency requirement. You know, there is a community with a city right on the border whose city clerk lives in an adjacent state.
But it doesn't say anything about that. That was just in the
Correct.
I know, I just wanted to make sure while we were discussing, and I confirmed my understanding.
Right. This is not to require that. It is purely a city's call as to whether or not they have that individual. Remember that in each one of the wards in these cities, we have an elected ward clerk, and that ward clerk is a resident of the ward. Okay. Now, it would be a different role for them to object and to oversee the city clerk, but it would not be, through the moderator, anything that affects the election at a polling place, it would not be out of question. All right, so we did 1 and we've done 2, allowing the opening of absentee ballots, the outer envelope and the pre-processing. One of the comments that we got from Dan was that the process should be the moderator. And I agree, the old process where we were saying that that's part of processing absentee ballots was the moderator. But one of the reasons I made it the clerk is to make it easier for that to happen in free time, so that the moderator didn't need to go into City Hall, 6 times a week during pre-processing, pre-election to go do that. And so if it's the committee's desire to move that back to the moderator, it doesn't, I think that it is much simpler. The clerk is already reviewing the application. They're reviewing the ballot that came back. They're going into ElectionNet. They are filling in the dates when these ballots went out and when they came back. They are familiar with the information. And if we ultimately pass the identity information on the application, they'll be checking that. I mean, there's a whole host of things that they're already doing with ballots. And I believe that opening of that outer envelope, or not sealing an outer envelope if they vote in person. Certainly no reason why that would actually even need to be sealed. But
well,
it doesn't talk to that.
Is there a way to word it that say the town and city clerks or the moderator, depending on who you're using? The other concern he had was shall open outer envelopes, where making it may, so that in case of a town election where you have very few absentee voters, like you said, right now they only have 80 ballots. They don't need to do the pre-processing at this point.
And that was going to be my next point.
Oh, sorry.
No, that's fine. If you look at I think it's page 2, line 33, where we talk about the pre-processing of absentee ballots, it says the moderator or the moderator's designee may authorize, and again, that may is in there for the purpose that you're talking about, that they may authorize the pre-processing of absentee ballots. And then down in the next section, that we take out the Saturday, Sunday, Monday thing that was in the old bill, and the wording in here in that next Roman 2 is after the corrected checklist to be used on election day has been posted, and based on reviews conducted per RSA, etc., notations may be made on the. So we've taken out the time constraint. I mean, as long as they printed that checklist, they can go do, and that wording is consistent with what's in there. The only thing that's really been taken out is the restriction on what day they can do it, and they get to pick now. And again, it's may make checklist annotations. You tell me which shall it is instead of a may, and we'll try to fix it. But those two in there, those two mays and those two sentences, I think does it.
Well, and the other concern he has was there was no procedure, what to do with the ballots after the pre-processing.
And page 3, lines 1 and 2, I believe. Reading from the middle of line 1, it says the ballot shall remain secure in the unopened affidavit envelopes until final processing on election day. All right. They are already storing these absentee ballots inside the city clerk's offices in most cases. And so however they stored them before, we would say store them that way. And as long as that envelope is unopened and you've stored them in a secure location, I'm good with it. If someone thinks we can improve upon that language, I don't necessarily think that they need to be put in boxes and have the red tape run around the boxes and all of that. We don't do it now. And the only difference is whether or not we've opened that outer envelope or not. The moderator still will have them and be able to inspect them when he's doing the pre-processing, and on election day when he's actually checking the voter in and doing all those things there. So
I understand that, but the minute you open those ballots, I think there needs to be some type of procedure, because once you open those ballots, you're leaving them.
So if we take
I think it needs to be standardized so that not every town is doing something different.
How would you like it changed? If I go into that page 3 and I say that the ballots shall be retained in a secure location, and the affidavit envelope unopened until election day, something like that. Will that do it for you?
The ballot shall remain secure in the unopened affidavit envelope. I guess the ballot shall remain in the unopened affidavit. I'm not sure. I have to get back to you on that.
How about putting in there, the clerk is responsible for the security of the ballots in, and security of the ballots, and shall, well, again, let me see if you're at least interested in assigning it to the clerk to do. They're the ones that have the ballots before this, and they would normally be the ones, in my experience, to have delivered or bring them to the moderator or to the polls on election day.
Does anybody else have any thoughts on this?
Yeah, I have a couple concerns with it. One was regarding when challenges would occur, and the transparency of that process.
Yep.
The other thing is the inconsistency with which somebody has the ability to cure. If you don't have a designated time, then someone might have 2 weeks, someone might have 2 days. And I think that's a concern. I think the more uniform the process is across the board, just because a city clerk in Portsmouth does the process one way and the city of Manchester doesn't have the staff to do it the same way, is inconsistent for the voters. And I just don't think that's a good way to proceed. I think having a more set time that's closer to election day. I recognize the burden of the work that's involved, but I think pre-processing certainly relieves a great deal of pressure on election day.
My response to that is that if you make me have a maximum time to cure, then if a voter was leaving for Florida 1 week before the election, they may not have an opportunity to cure. Whereas if I say it's 2 weeks before, then they would have. But then what happens if I open the outer envelope of a ballot on Friday, Saturday, or Sunday, because I am using the pre-processing point at this time, then do they get a chance to cure or not? And from what I'm taking from you, that once I say this is the start of my chance for cure, if you got your ballot in, you get an opportunity. If you don't, you don't. It doesn't sound consistent. I'm trying to give everyone the maximum time to cure based on when they gave me the ballot. If they want more time to cure, give me the ballot sooner. Okay? And they would be given that extra time. But I don't want to disenfranchise anyone because this person gave it at week 3, this one at week 2, and this one at week 1, and this one came in and delivered it while I was pre-processing ballots on the Saturday before the election. I want them all to have as much time as I can give them. We're at 12:24 right now, and I'm sure that I'm up against the next committee doing this.
Mm-hmm.
Again, we're hampered by RSA 91A not allowing us to have meaningful conversations with any quorum of the group that is not a caucus. So, if anyone wants to communicate directly with me and not through the group, we can try to do that, especially if you have questions. But
I just think there are a lot of
issues. But I can't continue to talk to you because our time is up.
Right. I was just going to say, I think there are a lot of issues with Section 3 and Section 5 that we would need to resolve before we can move forward.
All right, and we will continue this conversation on Monday.
I would make a motion that we come out of executive session.
Second.
We have a motion moved and seconded. And Senator Birdsall,
Yes.
Senator Ward, Senator Susie,
Yes.
Senator Rebecca Perkins Boca,
Yes.
and the chair votes yes. And a motion to adjourn.
So moved.
We have a motion. I'll second it. Okay. Senator Birdsall,
Yes.
Senator Ward, Senator Susie,
Yes.
Senator Perkins Boca,
Yes.
and the chair votes yes. Thank you all. And
What am I voting on?
you just kind of voted to adjourn, but
Yeah, oh, okay.
it was only
That's perfect.
nothing, but that's good enough.
Okay.
Thank you.
Okay.
Thank you
Thanks.
all.
Have a good day.
Thank you.
Bye.